what about the AI Act? It's the topic du jour. We're talking about it here and in other conferences. It's everywhere. And I guess it's landing at the desks of data protection officers. So whether we like it or not, as DPOs or indeed as legal service providers who service particularly tech and health companies, we're going to be asked these questions and we have to be able to help. So from a DPO perspective, we're currently looking at the EU AI Act. We're looking at various frameworks. We've partnered with IAPP, so we deliver the IAPP AIGP training. And that's a way of helping people understand what red flags to consider and whether or not the AI Act may apply to their processing activity. So the first thing, and I know Sue is going to talk about this in a little bit more detail, under the AI Act, it may not apply depending on the type of research that we're undertaking. It doesn't apply to AI systems or models, including their output, specifically developed and put into service for the sole purpose of scientific research and development. And there's going to be an interesting discussion, I think, as to where are we, putting it in for the sole purpose of scientific research and development, and then when we seek to commercialize it later, where does that lie? So that'll be these are some of the interesting things that we're looking at the moment. Obviously, depending on the type of AI that we're using, usually in healthcare, it's going to be quite a narrow AI with perhaps quite confined data sets, and hopefully the data cleaning and wrangling exercise has been well done. So we have good quality data. And that's essential, because without good data going into the system, without it ingesting appropriately managed data, we're going to get rubbish out. So depending on the type of AI system we're talking about, obviously we're going to have a different category. It could be high risk, unlikely to be unacceptable. But it's most likely, if you're talking about healthcare data, that it could be within that high risk category. And from that flows certain obligations. And that's again where we come in, where we take those obligations and we are working across the business to try and ensure that we develop out a responsible AI framework that matches our existing data protection framework, so that we're not having to do, two reviews, say, of ROPA, like what AI systems are we using, two reviews of or multiple reviews across the business on multiple occasions. We're trying to coordinate it as much as possible. So the situations where health research and use of personal data for health use could be classified as high risk. It could be because an AI system, as Peter said, is integrated into already regulated services. In Europe, we have the medical devices regulation and the in vitro diagnostics devices regulation. And I know Sue is going to talk about some of the similar regulations in a minute. Or because it's a classified high-risk AI system in Annex 3 of the EU AI Act. So if we are looking at developing out an AI product or service as part of the health research that we're doing, we may have to consider, if we are high risk, carrying out fundamental rights impact assessment. And again, what we're trying to do as DPO is take those obligations, standardize them, and implement them throughout the organization in a way that's not going to be a blocker to activity, but rather marry them with the existing processes that we have in place. So with, for example, our DPIAs, so what triggers a data protection impact assessment? Well, then we add in extra questions into that the DPIA questionnaire, and if certain questions are answered in a certain way, well, that will trigger that a fundamental rights impact assessment will have to be undertaken. And obviously, an FRIA is going to be a wider in scope. So it's going to look at things, not just privacy, it's going to be looking at other potential harms to the individual and to society. So we have to develop out a pure privacy risk assessment to consider these wider risks.